I'm honored to be here today and share some of my experiences with you. I have the greatest respect for USC holding this event. You've, over the years, chosen a number of very courageous topics, and I am so delighted with the challenge you put yourself as a community of learning. This year, you've selected a topic of pressing significance for All School Day. I will approach this topic as a human rights lawyer, but it's a topic for all professionals and all caring people in the world. Inequality in the United States and globally is advancing at a monumental speed. The richest 300 people in the world own as much wealth as the poorest 300 billion. And the powers that be in many countries seem not to care. All my life, I have addressed poverty as a legal problem, as well as a social problem, and I've tried to use my skills to attack it from that angle. I'm proud to have been a part of the legal services movement in the United States, and I've worked on trying to solve poverty in the United States. But in the last 10 years or so, I've had the honor to convene and participate in a group called the International Social and Economic Rights Project, a network of grassroots advocates, attorneys, judges, and academics who meet periodically to share experiences and problems, work on strategies, and disseminate ideas to the global movement of activists and lawyers who advance and enlarge social and economic rights. So today I want to share a bit of what I've learned from them, a development that has occurred during the course of my career. In this country, we are not very well informed about one of the most dramatic legal developments of modern times, the proliferation of progressive constitutions, primarily in the global South. Many of these constitutions came into being as a result of transitions from authoritarian regimes to democracy. Sometimes this was in conjunction with the decolonization process, as India after World War II. In the 1980s and the 1990s, a wave in Latin America of democratization replaced military dictatorships and juntas. In the early 1990s, South Africa saw the end of apartheid and a relatively peaceful transition to democracy. Advanced constitutional thinking appeared in Eastern Europe after the fall of communism, although many governments there are engaged in disempowering their judges as part of the new wave of right-wing anti-immigrant populism. These constitutions contain 4 elements that mark a sharp contrast with the U.S. constitutional tradition. First, they include among the fundamental rights not only political rights, such as freedom of speech and fair trials, but social and economic rights, such as rights to food, water, housing, medical care, education, cash assistance. Second, these rights are not mere statements of aspiration. They are made enforceable in court. Third, these duties that the constitutions place on governments far exceed the traditional obligation of government to refrain from violating or harming people's rights, such as denying you the right to vote. They place an affirmative or positive duty on governments to promote or fulfill social and economic rights. And finally, these constitutions greatly expand people's access to the courts and right to bring their cases to judges, far beyond what we have in the United States. Now, in taking these trajectories, the progressive constitutions send some very important messages. First, poverty is not just wrong or unfortunate. It is intolerable in a free society and therefore presumptively illegal. Poverty is prima facie unconstitutional. Government is in default of the Constitution and subject to remedial orders by courts unless it can be shown that it is taking reasonable measures within available resources to end poverty. It must take positive steps to allocate resources in a way that enables all people to lead a sustainable and dignified life. Second, people should have food, water, etc., not just because they need these things and because every human is entitled to access basic social goods without which life with dignity is impossible. They should have access to basic social goods for an additional reason, and this is the new insight of the social and economic rights movement. Poverty and democracy are incompatible. Citizens living in poverty cannot participate meaningfully and authentically in self-government. They cannot self-determine their lives either as individuals, as families, or as community members. The continuing unaddressed existence of poverty is inconsistent with human rights, both in that poverty offends the most minimal notions of human dignity, and poverty violates the basic precondition of democracy, that all people are enabled and empowered in their daily lives at a grassroots level to participate meaningfully in communal self-determination. But I don't want to pretend that writing social and economic rights into a constitution is a silver bullet that eliminates poverty. I wish it did. Law on the books and law on the ground are two very different things. History teaches that courts and legislatures typically do not take needed steps to give meaning to legal rights unless they are pressured to do so by grassroots organizations. Even when courts take bold steps to enforce rights, successful implementation of court mandates often requires active monitoring and participation by an engaged and empowered citizenry. So I want to give you 3 examples of the role of grassroots participation in implementing social and economic rights law. 1 each from South Africa, Germany, and India. And then I will bring these lessons back to the United States to conclude. First, 1996, after the long darkness of apartheid, South Africa adopts what is called by jurists and legal scholars as a transformative constitution. It includes things such as words, everyone has inherent dignity and the right to have their dignity respected and protected. Everyone has the right to have access to adequate housing. Everyone has the right to have access to health care services, including reproductive health care, sufficient food and water, Social Security. Now, progress has been made on many fronts, but there have been shortfalls and disappointments along the way. But the Constitutional Court's decisions on housing rights are perhaps the most developed than that in any other social and economic rights field. The Court's extensive attention to particularly eviction cases is partly explained by the profound trauma of forced evictions and removals during the apartheid era. Harmful effects of this legacy endure in the new South Africa. Still, a very promising development in access to shelter is illustrated in the conception of the doctrine of what is called meaningful engagement. Simply put, this rule of law requires any party, whether a municipality or a real estate developer, that seeks to evict tenants or even squatters from their homes, to first engage meaningfully under the supervision of courts with those whose eviction is sought. Meaningful engagement means genuine efforts to explore solutions that might avoid the need for eviction, such as on-site upgrading of the premises. No engagement, no eviction. As the Constitutional Court said in one case, one potentially dignified and effective mode of achieving sustainable reconciliations of the different interests involved is to encourage and require the parties to engage with each other in a proactive and honest endeavor to find mutually acceptable solutions. The court stated, people in need of housing are not and must not be regarded as a disempowered mass. They must be encouraged to be proactive and not purely defensive. Civil society organizations that support the people's claims should preferably facilitate the engagement in every possible way. In another case, the Constitutional Court stated that meaningful engagement must involve treating residents with respect and showing care for their dignity, and must include on the agenda making arrangements for temporary relocation while units were being developed, or if necessary, providing permanent alternative accommodations. Meaningful engagement exemplifies a process whereby people can experience the dignity of participating in making their own future. And it gives affected communities an opportunity to bring their knowledge of local conditions and ingenuity to bear so that public policy is crafted with an eye toward shielding vulnerable populations from deprivation. I see this as an example of how advocates of all disciplines working on issues of poverty and human rights might understand their work as not only aimed to ensure access to social goods, but also to give people the right to an authentic experience of democratic participation as a practice for empowering grassroots communities. Now let's move to Germany, whose Constitutional Court in 2010 took an unusual role in giving content to social and economic rights that activated civil society. A round of legislation in 2003, known as Hartz-IV, it's Roman numeral 4, but they call it FEAR, was a central plank of Chancellor Gerhard Schröder's Agenda 2010, which called for sweeping social reforms designed to, among other things, substantially reduce social welfare benefits. It was consistent with the contraction of the welfare state in many Western European nations. Poor people and their advocates challenged these reductions in what came to be known as the Hartz-IV case, as being in violation of Article 1.1 of the German Constitution, which says, human dignity shall be inviolable. To respect and protect it shall be the duty of all state authority. In the Hartz-IV judgment, the German Federal Constitutional Court carefully scrutinized the legislature's methodology in how it determined the welfare benefit amount. The court did something, in doing that, the court did something that is incredibly unusual in liberal constitutional tradition. It independently reviewed the government's calculations to assess whether they were empirically based. In modern constitutional jurisprudence, usually, and certainly in the United States, courts are admonished to defer to the legislature on such matters. Yet the Federal Constitutional Court took the position that the fundamental right to human dignity in Article 1.1 obligated Parliament to utilize transparent procedures to calculate what was a minimum subsistence amount for welfare grants. Moreover, the court held that it had the power and the responsibility to assess the accuracy of the calculations and to determine whether the legislature had employed a suitable method of calculation. The court required the legislature to tell the court how they had determined the calculation in some considerable detail, and found that Parliament had proceeded in an inadequate manner and required them to redo the calculation. Now, the court did not say whether the amount was sufficient or not. Instead, pursuing a conception of cooperative dialogue between the various branches of government, the court required the legislature within a specified timetable to redo their calculation and come up with a new amount. This process had a high profile in Germany and sparked extensive debate within civil society. Many stakeholders participated, and the political resolution that eventuated increased the amount of social assistance benefits. Now let's go to India in 2014. Two of my colleagues, both lawyers, formed a nonprofit called NASDEEQ to engage in human rights legal practice, hand in hand with grassroots organizations. I have time to only describe one of their amazing initiatives: their fight against maternal and infant mortality. India has the highest number of maternal deaths in the world. According to the United Nations, around 50,000 women die from pregnancy-related causes each year. 90% of these deaths are preventable. Insufficient budget allocations, weak implementation of policies, and poor monitoring and oversight contribute to a tragically high number of deaths, despite the fact that the right to safe motherhood is protected in the Indian Constitution. These human rights violations are particularly prevalent among women from Adivasi tribal communities who live and work in the tea gardens of Assam in the northeastern corner of India. Forcibly brought to work more than 150 years ago, over 2,500,000 families in Assam live in a state of generational servitude and lack access to services and facilities necessary to ensure safe motherhood. The lack of data on the Adivasi community makes it particularly difficult to address some of the gaps in the implementation of maternal and infant health policies. Unlike other Indian states, the Adivasi communities living in Assam do not enjoy what are called scheduled tribe status. As a result, the government does not collect disaggregated data on the Adivasi community, the large majority of whom are tea garden workers. This condition is exacerbated by low literacy and awareness of health rights among the Adivasi women, which affects their ability to report and monitor violations. As a result, the state of Assam has the highest maternal mortality ratio in all of India. NASDEEQ partnered with a local Adivasi grassroots organization to develop and implement the End Maternal Mortality Now project that combines social accountability, legal empowerment, contemporary information technology, and basic legal work. The project seeks to empower patients and communities to monitor and report instances of lack of health services and access to basic needs. Launched in April 2014, the project identified and trained a group of 40 local women, volunteers on issues of maternal and infant health rights under the law. The volunteers were chosen from different backgrounds and diverse geographic locations. They live in villages and in the tea gardens. They're housewives, social workers, and teachers. They were provided with mobile phones and a codified data entry system covering a range of maternal health issues. They developed a presence in the community and interviewed female tea garden workers and used their mobile devices to report instances where pregnant and lactating women could not access health and nutrition services and benefits required by the law. These instances were then mapped on an online platform and database and made publicly available at the project website. This data was then used for anything from making local health authorities aware of gaps, to media coverage, to advocacy efforts. This initiative has been enormously successful in casting a spotlight on service delivery failures, shaming and cajoling local officials to reallocate resources and improve systems, and above all, in empowering women, legally and otherwise. So now let me bring this back to the United States by way of conclusion. We don't have social and economic rights written into our Constitution. I know that's not a surprise to you. But transparency and data openness is something that we can fight for. When I see advocates in South Africa helping squatters fighting eviction defend themselves and take control of their lives, and I see volunteers documenting and publicizing legal health violations in rural India, I am amazed that my own city of Boston does not currently collect data on evictions. We don't even follow who is being evicted and where they end up. What does that mean for homelessness in my city? When I read about the Hartsfield case, I am amazed that virtually no state in the United States has to justify the level of benefits it pays to a poor family under temporary assistance to needy families, or any other social welfare benefit. We don't think we need to determine what poor people need in order to be able to survive. In Catherine Eden's new book, Living on Less than $2 a Day, she documented that we have 1.5 million households with roughly 3 million children surviving on cash income of less than $2 per person per day in any given month in the United States. 1 out of every 25 families with children in the U.S. live on that level. And we have no mechanism for calling our society into accountability for that. Why not? So while enshrining social and economic rights in constitutions or drafting progressive statutes that provide for social welfare for poor people is an important step, those rights are worth no more than the paper they are written on if grassroots communities and advocates do not use the space opened by legal rights to empower people to claim what is their due and stand up for human rights. It is not written in the Indian Constitution that local women volunteers have the right to call in health violations on their cell phones and map them. But that is human rights in action. They are being brought into democracy and are being empowered to make demands of their government and stand on their own feet. If we work with the everyday people whose lives depend on those rights, nurturing their dignity, and working with them to develop the tools such as NASDAQ has in the state of Assam, by giving meaning to those rights, we will make a difference, not just in putting food on the table and roofs over people's heads. I challenge you to struggle with bringing human rights home, bringing dignity home, bringing participatory democracy home. Otherwise, we have failed the vision of challenging inequality and poverty. Thank you.